Yeah, it's the most used medication in the history of mankind ever. There's a lot of cases out there for sure.
Welcome back to Tort Talk. This week we are back with the full team, all three of us, John Robinson, Marc Rioux, and Joe Fantini. Welcome back. The whole team's back together for the next little bit. As temperatures are heating up outside, things are heating up in the courtroom as we have some huge mass tort developments. John, what do we got cooking up right now?
Sorry to interrupt your regularly scheduled programming, but I wanted to talk about something that we built at RR Digital, a partnership model specifically designed to help your mass tort firm sign more cases. The right plaintiffs plus your firm equals more cases. That's the formula, and I cannot wait to show you how it works. Just visit rrdigitalmedia.com for more information. And now, back to the show. Well, so the biggest news of the week so far has been this announcement about the Tylenol MDL and the Second Circuit Court's decision to overturn this issue with the expert on the plaintiff's side being allowed to testify. Joe, what is going on here? Is the Tylenol MDL actually back on, or are we just taking sort of like a baby step back in?
Yeah, it's fully back on right now. So what happened? The MDL was going on, and then early in the case, the MDL court allowed for challenges to plaintiffs' experts. The defendants, as they always do, moved to exclude our experts. The judge in the MDL agreed and excluded all three of plaintiffs' experts, pretty much putting an end to that case. Plaintiffs appealed that up to the Second Circuit. We had the oral argument, and the decision just dropped, and it's not only the biggest decision to come down in the Tylenol litigation, it could be the biggest mass tort decision of the year, and here's why. It addresses the standard that the court can apply when acting as the gatekeeper in determining whether or not experts are admissible. So basically what that means is now the court has held that even if two experts disagree, even if maybe an opinion is different from one expert on the other side, as long as they use reliable methodology, the decision and the opinion of that expert should come in and go to the jury. So this is huge. The litigation's back on. I'm predicting it could be the biggest mass tort in history by the time we're done. And this is also opening the gate there a little bit further for a potential reversal in the Zantac MDL decision, which excluded all of our experts. That could be coming down before the end of the year as well. So a lot to digest there. But what do you think about that, John?
Yeah, I've talked to a number of firms since this ruling came down, and at least the ones that I've spoken to are, I would say, cautiously optimistic and kind of in like a wait and see pattern about what happens next. I don't know. I mean, I agree. The volume is there. Everybody was really excited about this about a year ago, and then it just fizzled when this decision came down. I don't really know where we go from here because it could be so big. It's one of those like too big, right, of an MDL.
And that's what happens sometimes. The cases get too big, they get out of control. And, a huge decision is pretty much, amidst our experts. We still have to prove that specific causation and convince the jury. But we also have to factor in we're going against J&J in this case. We're going to talk about the Talc litigation that's going on 15 years. So trust me, their signature products that they've made hundreds of billions of dollars on, they're not rolling over anytime soon. So this is still going to be a drag out fight, but it's a huge decision for plaintiffs. The litigation's definitely back on. And like I said, the impact of this decision on all of the mass torts going forward, that's what I think is the bigger takeaway.
Great to see positive news in the world of pharma, for sure.
I foresee this one can easily just get over 100,000 claimants very quickly. And like you said, this is like a marquee drug that it's probably one of the most popular drugs in the entire world so you can buy from a pharmacy.
Yeah, it's the most used medication in the history of mankind ever. There's a lot of cases out there for sure.
Oh, can't wait to see how this one heats up. Moving on to talcum powder. Speaking of experts, a big filing in the Talcum Powder MDL with the report and recommendations from the special master related to plaintiff experts Dr. Longo. How big is this recommendation, Joe?
This is huge. So basically what happens in these larger MDLs is the MDL judge relies on special masters for specific aspects of the case. It could be discovery disputes. It could be something related to the expert. So in this instance, the MDL judge is having the special master review and hear the evidence related to specific experts. The special master issues what's called a report and recommendation. That goes to the MDL judge who reviews it, reviews the evidence, and ultimately issues the decision. But with Dr. Longo, the special master is saying that certain key testimony and key evidence should be excluded. So this is one of plaintiff's main experts in this case. One of the testing that he utilized related to whether or not there was asbestos in the talcum powder is being challenged, basically, and the special master says it shouldn't come in. Right? This doesn't cause the whole case to collapse. It's not the end of everything. Like I'm sure, J&J's puffing out their chest and saying it's only a report and recommendation. We don't know if it's going to be adopted, but it's definitely a win for J&J. The litigation still goes on. As we see, both sides always score points in these big mass torts. So it is a win for J&J, but it's not the death bell that I'm sure they're acting like.
Ooh, wasn't expecting that one to come down.
Yeah, we were surprised by that decision. So not the best of news, but cases are still going on. There's 70,000 cases filed. The inventory is going to keep growing.
We have another trial going on right now. This week we had the Covidien Hernia Mesh Bellwether trial get underway. I know Kelsey Stokes and David Hobbs are involved in that, and they've been very much involved in the hernia mesh litigation since its inception. What can you tell us about this trial specifically as it relates to Covidien versus other manufacturers?
Yeah, so I recall you had David and Kelsey on, back out in Vegas previously, and they were talking about the Covidien litigation. So right now we have a parallel litigation going on in Massachusetts State Court, where Covidien's home, and then also in the MDL. So in the MDL, there's about 25,000 cases. In Massachusetts State Court, there's a little over 6,000 cases. So we almost have 10,000. By comparison, Bard had about 30,000. Covidien controls about 25% of the market share. But this litigation has dragged out for almost a decade. Part of the reason is because we started off with a tolling agreement that really didn't accomplish much, just delayed. But finally, we're able to get this first case to trial in the MDL. It's a Symbiotex. So I always describe meshes like car manufacturers. Ford, they have a Ford F-160, they have a Ford Mustang, they have a Ford Focus, a Ford Escape, all these different types of cars. So a Symbiotex is a specific type of mesh. This trial is going to last about a month. This was a plaintiff pick. We're feeling pretty good. If you remember in Bard, we did 4 trials, 3 wins, 1 loss. And I think we're going to have to do a couple trials here by Covidien, but I think this is going to come out good for plaintiffs. Stay tuned. Sometime mid-August, we'll have a verdict.
Is this the last of the manufacturers, right? Like, I think that Bard's done, Covidien's the last one, right?
Yeah, so pretty much all of the other manufacturers have settled. So Ethicon was another big one. They had a physio product that settled. They also had Proceed and PHS cases. Atrium was another manufacturer. So this is really the last significant manufacturer standing. Hopefully we can get a resolution here, maybe by the end of the year, with some good trial results.
Moving on to our last topic of the day, and something we've been talking about a lot recently, is Roundup. We have the final approval hearing set for August 19th for the Missouri class action. What are you hearing in anticipation of this hearing?
Yeah, so the hearing got pushed back from July 9th. The court wanted to give the parties, objectors, opportunity to brief, and then also brief on whether the issue should stay in state court or if it should be in federal court. In the meantime, we had that Supreme Court ruling that came down in favor of Bayer, preempted the failure to warn claims. In the MDL, they argued all of the cases should get dismissed because all of the other claims, negligence, design defect, warranty, etc., were basically encompassed in that failure to warn decision from the Supreme Court. The MDL court rejected that, so that was good for plaintiffs. And then we recently heard from Bayer in some publications that they fully intend to move forward with this $7.25 billion settlement. They're eager to bring these cases to a resolution. Majority of plaintiffs are on board with this. So I think the hearing is going to go forward on, like you said, August 19th. And hopefully we have a decision early fall resolving those cases in Missouri State Court.
You know, I would love to see some closure in some of these mass torts, especially Roundup. Was not expecting a settlement in a class action like this, but I'm happy to finally see some closure on this long legacy mass tort.
Yeah, it will be good to wrap this one up and hopefully some of the other ones we've been talking about over the years before the end of the year.
It's fantastic to be back together. The gang is back. Joe, Marc, feels good. Feels good.
Yeah, happy to be here with you guys. Looking forward to connecting next week to give everybody the latest updates in the world of mass torts.
Thank you, Joe. We'll see you guys next week.